Hey guys, I'm James Brown, an attorney at James Brown Law and founder of Title Leap, and today we are talking about the infamous paragraph 8 in the FAR bar, the financing contingency, the most frequently talked about paragraph in the entire contract. The financing contingency is the single paragraph I get the most calls from agents during the course of the week on week after week after week. It is one of the most frequently misunderstood paragraphs in the contract, and I can tell you from firsthand experience, I get calls from seasoned agents that don't understand how it works, that aren't aware of all the provisions. So if you as an agent know this paragraph inside and out, you will have a leg up on your competition for sure. The first topic I want to talk about, the first defined term in the paragraph I want to talk about is loan approval. It's very important that when you talk about loan approval in addendums that you use capital A, capital L, capital A. So that's a defined term, and you want to use that in the way it's referred to in the contract in any addendums. The buyer is under a duty to give the seller prompt notice of loan approval or loan denial. That's on line 103. It's important that buyers don't have to give sellers a copy of the actual loan commitment or loan denial letter. In past FAR bar forms, we're using the 2017 version of the FAR bar. In past FAR bar forms, and we're only talking about the FAR bar in this lecture, there was a requirement that you deliver the written loan denial or the written loan approval. In the new Florida FAR bar form, that is not a requirement, just a written communication from buyer to seller, letting them know that you got or didn't get the loan. Once the buyer communicates the loan approval to seller, the buyer is under a duty to close and shall lose their deposit unless one of three things occurs. Seller defaults on the contract, property related conditions that were a burden of seller have not been completed, or the lender's appraisal value was not sufficient to meet the lender's loan approval terms. There is a recent case, however, called Lafont, and Lafont says the buyer must close even if the property underappraises if they fail to give notice during the loan approval period. So that's critical. It's critical that the buyer applied for the loan that they stipulated for in the contract. What's not clear from Lafont is if the proper loan was applied for and the buyer did not give notice, the loan approval would lock the buyer in to close. If the buyer does not give notice of loan approval, the contract says the buyer is deemed to have obtained the loan and the deposit becomes non-refundable. It's important that in this event the seller can cancel the contract within 3 days of the expiration of the loan approval period. I've seen some really disastrous outcomes on this. I've seen buyers get levered into additional money in the purchase price because the sellers canceled, buyers had kids starting school shortly, and the realtor for the buyer knew that the financing was solid. They didn't give notice and the seller took advantage, canceled the contract, and made the buyer put up a little more money as a purchase price to actually make the loan close, make the transaction close. Also in the contract provision is a duty on the buyer to use diligent effort to pursue the loan. So for example, if your buyer is slow to respond or doesn't respond and they think they're just going to cancel because they're not giving the lender the information, they're actually in default of the contract. So if the buyer later tenders notice that they were denied for the loan, then the seller could argue that they are in default and they shouldn't get the deposit back, and now you have a deposit dispute. The buyer has a duty to timely communicate the status of the loan to the seller. This is stipulated in the contract. Again, in FAR bar forms past, the sellers did not have, and the loan officers did not have authority to communicate directly. In the new FAR bar form, this is authorized, so take advantage of that. That's on line 99. Hugely important, loan approval that is conditioned on the sale of another property belonging to buyer is not a loan approval. So if you are one of those agents who does send a copy of the loan approval letter from the lender to the seller, and it's contingent on the sale of buyer's other property, you have not conveyed anything. And that's another situation where the seller could cancel. And we did have another transaction aside from the one I told you a few minutes ago, where they sent over loan approval subject to a sale of other buyer's property, and the seller canceled, and the buyer couldn't understand what was going on. But again, the seller levered the buyer into a position where they had to spend more money to close. In times of rising markets, sellers are looking for any reason to get more out of their sale price, so just be leery of that. Buyer must give written notice of a loan denial if they want to cancel. If no notice of loan denial is given, the buyer is deemed to have gotten a loan. We talked about that a little bit earlier. Important, the loan denial does not have to be the denial letter. Again, it can just be a letter from buyer to the buyer's agent saying that they didn't get the loan, and that letter can be forwarded to the seller's agent. The contract authorizes direct communications with the parties, so that's important because what happens is sellers, agents, if they get the written denial that isn't the denial letter, they just get the statement from the buyer. I frequently get calls from sellers agents that want to make sure they didn't get the loan. So remember, you have that authority. Copy the buyer's agent on the communication lender and just ask, was the buyer truly denied? That's not a violation of the contract, and you have that authority, and then you just want to keep the buyer on notice when you're doing that. Some additional thoughts. The diligent seller's agent stays in touch with the lender in writing and keeps the buyer's agent CC'd on the emails. Most important thing, the earlier you know, the better. Appraisers are restricted to communicate with the party that ordered the appraisal, and that name is going to appear on the appraisal order form. So by law, that is the only party that the appraiser is allowed to communicate with. So if the appraiser says they can't talk to you, that's what they're relying on. The difficult question arises, and I could not find any great bright line legal rules or tests. When the buyer is approved for a loan and they communicate the approval in writing, and then the buyer is later denied for the loan, not for an appraisal issue, who gets the deposit? And I will say there weren't any great cases on this that I could see. So they get the approval, then later they send the denial, and I have a couple of these cases that we're working with right now. And I will say, however, even though I couldn't find any bright line tests on this, in all these situations we were able to get the deposits, or the vast majority of it, back in favor of the buyers. This has been Jim Brown. Thanks for watching Title Talk one more time. Don't forget to hit like and subscribe. See you next week.